Breaking information coming in right now and this was much faster than we expected it to be. The Karnataka flow test has been slated for 4 p.m. tomorrow. The Supreme Court orders a flow test on Saturday. Now this is much faster than or much earlier than the 15 days that had been awarded to B.S. Yediyurappa by the governor. The Karnataka, the Supreme Court has now intervened and shortened, as we had expected, the time offered to the BJP to prove its strength on the floor. Remember, we had expected this to happen perhaps on Monday morning, but Saturday evening 4 p.m. actually just gives the MLAs in Hyderabad enough time to come back to Bangalore, but it doesn't give, and from what we understood from the arguments made in court, it doesn't give the BJP enough time or as much time as they would have liked before this floor test.
There is one other implication, and I guess a rather important one, which is almost a repetition of what has happened in Goa, that while if this is the final order, then while the Supreme Court has respected the discretionary power that the governor enjoys, it has certainly questioned the intent behind the time duration that has been given. So in many ways that has been almost, without saying so, termed a bit of matter of ID.
Yes. In fact, a couple of things that I have to remind our viewers that the Supreme Court has right now decided that the floor test will happen at 4 p.m. tomorrow in Karnataka. The Congress had initially assumed that the Supreme Court would either set aside the governor's decision or set aside the chief ministership or the oath that B.S. Yediyurappa had taken yesterday. That is not what happened. Remember, legally, the only room here for the Supreme Court would have been to shorten the time given for the floor test, and that's exactly what the Supreme Court has done. A very quick decision, actually, within the hour of the court actually resuming to hear this this particular case. Meenakshi standing by with information. Meenakshi, could you tell us what the mood was like inside of court, especially it seemed like tough talk there between Justice Sikri and Mukul Rohatgi, where the judge gave him two options, either a floor test or a change in the law.
Well, Frey, at the outset, as first reported on Mirror Now, that the Supreme Court would indeed advance the floor test. If you'll recall the last conversation we were having, we were exactly on this point of law that the Supreme Court would go ahead and advance the floor test as early as tomorrow, which is Saturday. And as we are speaking and as the detailed order is being dictated, the big breaking news is that indeed the Supreme Court has advanced the floor test to tomorrow. 4 p.m. is the time that has been allocated, and this has happened in spite of Mukul Rohatgi opposing early floor test. Congress-JDS combine is all ready for a floor test to be conducted at the earliest. Abhishek Manu Singhvi, Kapil Sibal, all of the opinion that this is something which warrants the immediate floor test. But Mukul Rohatgi was of the opinion that some time should be allocated. He was looking for time till at least Monday. That has clearly not happened. And of course, floor test is going to be conducted.
Final order, Meenakshi.
The supervision of the Supreme Court tomorrow, 4 p.m. is the
Meenakshi?
time. And
is this the final order? Is the final order being read out at this point, or is this part of the final order?
This is the final order. There will be other clauses that this order will contain, like, for instance, the security arrangement, videography of the assembly proceedings, deployment of marshals for security purposes, etc. But insofar as the crux of the matter goes, 15 days' time, Supreme Court has found to be exceedingly unpalatable in a situation of this nature. Congress-JDS combine's demand for an early floor test has been accepted. Floor test is happening tomorrow, 4 p.m. and the other portions or other directions are being noted down. Of course, they will include some other features to this order, but this is the moot point. 15 days are not acceptable, something not palatable as per provisions of law, according to the Supreme Court as well. And Mukul Rohatgi is seeking time till Monday at least, so that respective MLAs could come back and participate in the floor test. That demand also not cutting ice with the Supreme Court.
Right.
And
Right. So Meenakshi, obviously, are these lawyers still inside of the courtroom at this point? We understood at one point, Mukul Rohatgi also said that he opposed the idea of a floor test on Saturday. What were the justifications he offered for that opposition of that for that statement?
Yes, Faye, according to Mukul, tomorrow would be very early, given the fact that the MLAs are at different locations and they need time to really head back to participate in the proceedings pertaining to the floor test. But clearly, that is something which the Supreme Court doesn't quite agree with, given the fact that the other side, the Congress-JDS combine, is all ready. They want a floor test at the earliest. So this is something which really the Congress-JDS combined would not mind, given the fact that two of their stalwarts from Abhishek Manu Singhvi to Kapil Sibal were pitching for an early floor test, and 15 days time by the governor clearly is something which has just not cut ice with the Supreme Court. So yes, while Mukul wanted a little bit more time, according to him, time which was needed for the MLAs who perhaps are dispersed or in their other areas of work to get.
This is a judgment and an order that must be celebrated throughout the country as a vindication of democracy. The faith of the people of India in the wisdom of the Supreme Court stands vindicated once again.
And this is the big setback for BJP?
It is quite clearly a big setback for a party that wanted to usurp power without the numbers, and it is a victory for democracy.
Yeah.
Their advocate and senior leader Congress, responding to the judgment that we've just heard. So, Vinay, this was very quick. We didn't expect a 1-hour hearing and an order this quickly. Floor test tomorrow at 4 p.m.
Yes, the order came very quickly. Absolutely, I think we expected a little longer. And as I said earlier, I think the most important implication of this order is really that while the court has acknowledged the discretion of the governor in inviting somebody, they have certainly indicted the governor in the duration that he gave. 15 days is now sounding so absurd, because the court is very clearly saying you need to do it tomorrow. That's almost 48 hours.
Especially after they vote, they've sworn him in. He's been sworn in. He's chief minister. So 15 days then would seem...
And not just that, not just the fact that they've sworn him in, but the fact that the person who's taking a claim to the former government actually asked for 7 days, and the government ended up giving double of that.
Yes. All right. Hitesh Jain is still with us. So is Ramakant Gaur and Gaurav Vallabh of the Congress party. Hitesh Jain, setback here for the BJP. Are you seeing this as a setback? Because we know the council representing the BJP actually argued against an advanced floor test. He said they weren't, he opposed it. We don't know what his arguments were. We know for sure that he opposed a floor test tomorrow morning. Can Hitesh hear me? All right. I'm not sure if Hitesh can hear me. Ramakant Gaur, is this a setback for the BJP?
Undoubtedly. And this is not only a setback to BJP, this is a setback to the governor's arbitrary usage of the discretion. Governor has exaggerated or has outcrossed his jurisdiction. Yes, constitutions confers him powers to exercise the discretion to call upon the leader of the large party. At the same time, giving 15 days time was not only arbitrary, it was nullified and unconstitutional as well. Supreme Court addressed that issue, and now the verdict is out.
In fact, let me go. We're going to try and get Hitesh Jain back in again, but while it is obviously a setback for the BJP, given the fact that they now have to make sure that something, simply from a planning point of view, they thought they had 15 days for something, they now have 24 hours.
And I think the Supreme Court's decision to reduce this duration has also leveled the playing field in many ways. The minute you give a party 15 days to try and prove the majority, it's not a level playing field, because you've obviously allowed that person too much of time. In fact, double the time that he himself asked for to try and play out whatever other games that you have to play out to break away other parties. And very clearly now, twice in a row, the Supreme Court has reduced the time that the governors have given to political parties for proving the floor of the majority. So now you have two precedences. You have one in Goa now.
Which was 48 hours, and this is 24
hours.
No,
technically from the date of swearing in, that will also be 48 hours, because he was sworn in yesterday. So technically, if you see, 48 hours technically now becomes a bit of a benchmark now for all governors, and they'll be tested against that.
But he's going to be a little disappointed, because he spent a lot of yesterday in meetings and not exactly getting down to work, because like I said, he would have assumed he had a larger amount of time. One of the things that he did yesterday was pull security from those MLAs and then send them off to Hyderabad, which might have made things a little more difficult actually for the BJP right now than for anybody else. Hitesh Jain, this judgment is a setback for the BJP, obviously.
Well, I don't think so. In fact, this judgment vindicates our position. They had challenged the decision of swearing in. They had challenged the appointment of Mr. Yedurappa as the Chief Minister. They had challenged the order of the dismissal of the governor. They have not agreed. The only request is we mentioned about like Monday or Tuesday. We also on our own volition said we are agreeable for an early floor test. All that what we have been demanding is a floor test. We welcome the decision of the Supreme Court and we are ready to face the floor test. In fact, this judgment vindicates our position. The Congress plea of setting aside the governor's decision to invite Mr. Yedurappa to be sworn in as a Chief Minister has not been allowed. What has been been done by the Supreme Court is advancement of the floor test, which is what at the end of the day we wanted the floor test. So, in fact, this judgment vindicates our position and we welcome the decision of the court.
In fact, let me just point out to you, I think the court has made an observation that the senior most member, the court has made an observation that the senior most member in the House will be the pro tem speaker, and the speaker will decide, the manner in which the floor test should be held. Now, when we say manner in which, Gaurav, I'm going to come to you, but first, what are the different options here to have a floor test?
Well, look, usually in a split mandate situation, the parties will obviously ask for a division of votes. Yeah. Technically, you can go for a voice vote, but I don't think in such a fractured mandate, anybody would ever agree to that. There will be a formal division of votes, and this process obviously has to be conducted by the pro tem speaker, which is usually the norm. The pro tem speaker does manage the House in the absence of a full-time speaker. But look, I mean, I had a question to Hitesh actually.
Yes.
And Hitesh, my question is very simple to you. Let's for a minute not talk about BJP or Congress. I am going to ask you a question about the neutral, and I am using the word neutral with great deliberate care, the neutral office of the governor of Karnataka. He is a constitutional authority, he is neutral. As a political observer and a spokesperson, would you not agree that if a court says that you do, instead of 15 days, you really have only 48 hours, it casts aspersion on the decision of the duration that was given to a particular party? Is that not an indictment?
Well, Vinay, I think your argument is something similar to the argument of the Rahul Gandhi. When Congress lost in Gujarat, they claimed the moral victory. Here, there is no question of any moral victory or vindication. Mr. Yedurappa himself said yesterday they are ready for the early floor test. Mr. Rohatgi also yesterday in the midnight hearing mentioned to the Supreme Court that they are ready for the advancement of the floor test. So, there cannot be a vindication or something. At the end of the day, what the governor said, it had given 15 days for the floor test. 15 days is the outer limit. The floor test can be held anytime. So, one should not look into that now that, oh no, I mean, what is important is that the plea of the Congress for asking the setting aside of the judgment, decision of the governor has not been accepted, and the fact that the governor's decision to invite the single largest party stands correct. So, that is the most important point. I mean, one may try to see that, oh, because this is not suiting the this thing, now you float the theory, instead of 15 days or 2 days have come. Nothing changes.
No, but Hitesh Jain, the lawyer representing the BJP in court opposed having a floor test tomorrow. Is that because the BJP is not ready?
No, I don't think so. I mean, I'm not aware about what exactly has transpired in the court. Maybe, but the same lawyer also had suggested that they are ready for the early floor test. Now, in what context the question, whether it is tomorrow or day after tomorrow or Monday, it will be very difficult for me to speculate in what context. We do not have the transcript of the hearing. So, therefore, I would not like to make the comment. But very simply, Mr. Yedurappa said that they are ready for the early floor test. Mr. Rohatgi himself mentioned they are ready for the early floor test.
No, I believe you're misinformed. I believe you're misinformed. Forgive me for interrupting you, Hitesh Jain. It was Mr. Singhvi, Dr. Singhvi representing the Congress JDS who said that they're ready for an early floor test. And Mukul Rohatgi, who's representing the BJP, said he actually opposed that idea. And I don't recall B.S. Yedurappa at any point making a statement saying that he's ready for an early floor test. So actually, I understand you don't want to comment on what's happening inside of court, but my question to you, let me rephrase the question, please. Is the BJP ready? Does the BJP have the numbers right now for a floor test tomorrow?
Well, we have asked for the floor test. We are ready to face the floor test, and we are happy to face the floor test tomorrow. So, and we have written in the letter that we will prove the majority on the floor of the House. So, we have the numbers, and on that basis, we have staked the claim. So we welcome the decision of the Supreme Court and we are ready to face the floor test. In fact, on the contrary, till today, Supreme Congress was not ready for the floor test. Now, when they realize that they are not going to succeed in the court, they have just given a tactical retreat. It is not Mr. Singhvi's case that instead of 15 days, you give me 2 days floor test. Mr. Singhvi wanted the order of the governor to be set aside. That is the relief they had sought in the petition. Their petition was not that you advance 15 days to 2 days. Now, when they saw that they have no position to get any relief, they want some sort of this thing to say, okay, we got an early floor test. So what? We have been telling that come, be man enough and face the floor test in the House. Don't run away from the floor test.
I don't believe anybody was running away from a floor test.
If they would have agreed for the floor test.
Do we have Gaurav Vallabh?
No, okay, but then why was Congress wanting? You heard Mr. Gehlot. Mr. Gehlot said that they want the governor's order to be set aside.
Yeah, I do believe that was the Congress's first aim with this. With this entire thing, but that seems to have changed. I just want to give you updates, and these updates we're getting right now, and we'll confirm them in a bit. So, floor test tomorrow at 4 o'clock is what we know for sure. Pro-Tem Speaker will choose the mode of the test. The court has apparently turned down the AG's request for a secret ballot. We also know that no Anglo-Indian nomination will happen until after the floor test is done. So, and B.S. Yediyurappa will not be able to take any major policy calls, and the DGP will ensure the safety of the MLA. I want to go back to this secret ballot. So if there was a request for a secret ballot and it has been turned down by the court, what implication does that have?
The implication is very clearly is that when you do not, in the absence of a secret ballot, who has voted for who is public knowledge. And if in the event of cross voting, you will end up attracting the provisions of the anti-defection law. Also remember, it's very significant that the court has said that the MLAs will take oath tomorrow. I'm assuming, and I think the oath will happen before the floor test happens. If you remember, yesterday in the midnight hearing, this argument was raised where there was a question asked by the judge, and the Attorney General or one of the lawyers representing the other side had replied on the legality of what is the point at which an MLA is actually an MLA. Is a person an MLA when he collects the certificate from the returning officer, or does he become the MLA when he actually takes oath in the assembly? And I think the Supreme Court in many ways indirectly has settled that. That if there is a doubt over what's an MLA and hence can't...
I believe Abhishek Manu Singh is making a statement. We just got across to that, please.
All of you give your mic to one lady. Two ladies. अपना mic दीजिए. Mic
यार आप लोग बैठ जाओ.
आप बैठ जाओ.
यार
आप बैठिए, अपना माइक दीजिए इनको, लेडी को दीजिए.
आप बैठ जाओ, बैठ जाओ. अरे आप बैठ जाओ यार, थोड़ा सा बैठो तो. बहुत आप बैठिए. नहीं आप बैठिए.
I'm leaving. I'll leave. If you don't keep quiet, I'll leave. Please, I have to leave. Please, सर नीचे रखिए. एक साथ
एक मिनट आप नीचे बैठो. मैम प्लीज आप बैठो एक बार.
ये पकड़ लीजिए.
हाँ पकड़िए. एक दो माइक हमें देंगे यार. एक दो माइक बहुत आप लोग बैठो.
नीचे बैठो.
बहुत आप आगे जाइए ना बस.
जब तक आप लोग बोलेंगे मैं नहीं बोल सकता हूँ. प्लीज डोंट स्पीक.
आप बैठिए. बहुत आप बैठिए. आप आगे जाइए.
माइक हटाइए. नीचे होइए. मैं बोल रहा हूँ. प्लीज कीप क्वाइट. नो नॉइज.
प्लीज कीप क्वाइट. इसको नीचे रख लीजिए प्लीज.
अच्छा अब सुनिए.
बहुत सुन लीजिए.
सुनिए शांति.
भैया सुन लीजिए चुपचाप.
मेरा चैनल तो आने दो भैया. मेरा चैनल तो आने दो. नीचे करो.
अरे एक मिनट. नीचे यार आप चिल्ला रही हो, आप बैठिए, बैठना पड़ेगा, बहुत थोड़ा सा नीचे।
अब शांति, क्वाइट। मैं बोल रहा हूँ, नीचे करो ना भैया।
नीचे रखो माइक।
मैं हिंदी में बोल रहा हूँ और इंग्लिश में बोल रहा हूँ, आप शांति मेंटेन करें, बोले नहीं बीच में। मैं पहले बोलूंगा हिंदी में, फिर अंग्रेजी में, बोलिए नहीं बीच में। प्लीज डोंट स्पीक। आई रिक्वेस्ट यू, आई बेग यू, प्लीज। रास्ते में नहीं आइए और माइक नीचे रखिए। माइक ऊपर आ रहा है, आप बैठ जाइए नीचे, ऊपर नहीं उठिए। फ्रेंड्स, आज उच्चतम न्यायालय ने एक ऐतिहासिक आंतरिक आदेश दिया है। वो ऐतिहासिक आंतरिक आदेश के अंतर्गत कई बहुत ही प्रमुख आदेश दिए गए हैं। पहला कि तुरंत फ्लोर टेस्ट होगा, कल होगा। फिर फ्लोर टेस्ट होने के पहले 4 बजे के पहले सभी को ओथ दिया जाएगा। एक प्रो टेम स्पीकर के अंतर्गत सबसे महत्वपूर्ण, येदियुरप्पा जी के वकील ने खुद ने ये माना और कहा कि आज से कल तक येदियुरप्पा जी कोई भी नीतिगत निर्णय नहीं लेंगे। साथ साथ बार दलीलें की दूसरे पक्ष ने कि समय कल का न होना चाहिए, आगे का होना चाहिए। इन दलीलों को नहीं माना गया और कल के लिए रखा गया है विश्वास मत। मैं समझता हूं कि सही रूप में जमीनी सच के आधार पे ये सबसे अच्छा निर्णय है। लेकिन साथ साथ जो हमने बहुत महत्वपूर्ण कानूनी मुद्दा उठाया था, उसको पूरी तरह से बरकरार रखते हुए उच्चतम न्यायालय ने उसको भी सुनने के लिए 10 हफ्ते बाद तारीख लगाई है। वो महत्वपूर्ण मुद्दा है कि क्या राज्यपाल जी पहले ऐसी पार्टी को निमंत्रण दे सकते हैं जिनकी गणित बड़ा स्पष्ट है, बड़ा साफ है, बड़ा पारदर्शी है, सिर्फ 104 की है, और उनके सामने पत्र हैं और दलीलें हैं कि दूसरे पक्ष की यानी हमारे पक्ष की यानी जेडीएस और कांग्रेस के पक्ष की 117 है, 116 है। अगर ये बात है तो हमने मुद्दा उठाया है संवैधानिक कि कैसे राज्यपाल जी ये कर सकते हैं। वो मुद्दा भी उच्चतम न्यायालय निर्णित करेगी निकट भविष्य में। और आंतरिक रूप से ये आदेश भी दिया गया है कि कल दूध का दूध और पानी का पानी साफ हो जाएगा विश्वास मत पे। अब साथ साथ कई प्रकार के सेफगार्ड्स प्रावधान दिए गए हैं। एक और महत्वपूर्ण वक्तव्य रिकॉर्ड किया है कि किसी अतिरिक्त नए एमएलए को एंग्लो इंडियन समुदाय के आधार पर निर्वाचित नहीं किया जा सकता। विश्वास मत के पहले मनोनीत नहीं किया जा सकता, विश्वास मत के पहले। ये सबसे और इसके लिए भी हर प्रकार का विरोध हुआ। ये कहा गया कि कल नहीं होना चाहिए, बाद में होना चाहिए, नीतिगत निर्णय लेने दीजिए येदियुरप्पा जी को। इन सबको नहीं मानते हुए उच्चतम न्यायालय ने एक अत्यंत महत्वपूर्ण आदेश दिया है। हमारी पूरी विश्वास है और आशा है और 100% विश्वास है कि विश्वास मत भी हम कल जीतेंगे और अंतिम जो इसकी सुनवाई होगी याचिका की, उसमें भी हमारी आशा और विश्वास है कि हम विजयी रहेंगे। लेट मी एक्सप्लेन टू यू फ्रेंड्स, डोंट स्पीक, दैट it is a historic interim order. The order is historic because the court has directed a confidence motion within less than 36 hours. The confidence motion is subject to many safeguards. Members of the Anglo-Indian community cannot be nominated. Mr. Yediyurappa conceded through his counsel that he cannot have any major policy decisions taken. Security was provided. A pro tem speaker, not a regular speaker, will conduct. He will swear in everybody before 4 o'clock, and all will assemble and have the vote of confidence at 4 o'clock. Most important, the court has kept our main point alive for final and future hearing. The main point alive for final and future hearing after 10 weeks raises an extremely important constitutional point that he had to invite that group which had election commission certificates of more than 117 MLAs. It is clear that the Yediyurappa letters disclosed today did not give any details. येदियुरप्पा जी की चिट्ठियां जिनका आज खुलासा हुआ, कोई भी उसमें तथ्य नहीं थे कि किस आशा और विश्वास पे उन्होंने बहुमत मांगा है। उन्होंने कोई तथ्य नहीं दिया ये बताने के लिए कि क्या आधार है उनका ये विश्वास, ये बहुमत मांगने का। Therefore, it actually in a way according to us proves our point that he had no basis for laying stake to form the government. Friends, we are extremely grateful to the Supreme Court for sitting at night, for sitting today, and for giving both a pragmatic solution and also keeping the main principle alive to be heard and decided shortly. Thank you.
There we have it. That's the decision right now. And a very interesting thing emerging from what Abhishek Manu Singhvi was just telling the press outside of Supreme Court, that this is an order, interim order. The Supreme Court has not fully disposed of the case. Vinay, that there's more to come.
Yes, I think in fact that's actually the most important part of whatever he said. I mean, the new part that he said, that this petition has not been disposed of, which means the Supreme Court will still go into the argument, the merit argument of whether the decision to call the one particular party in the absence of formal letters of support was valid or not. So it's a very, very significant point. They haven't disposed it of.
Right. Let me go across to Mr. Soli Sarabji, former Attorney General of India and also very, very senior jurist, brilliant legal mind. Mr. Sarabji, thank you so much for joining us here on Mirror Now. We appreciate your time. I'm going to come to you first with the Supreme Court interim order that we have received asking for a show of strength as early as 4 p.m. tomorrow afternoon. What is your reaction to this order?
Well, Supreme Court has rightly affirmed the principle. The question of majority has to be determined on the floor of the House. And that's absolutely correct. The only question is whether the time given, namely 4 p.m. Saturday, is a bit too short for the parties to really gear up and get the people around. But it's another question. But in principle, the order is correct. The floor test is the right forum to determine the question of the majority of the party which claims to form the government. And to that extent, I can find no fault with the Supreme Court order, except, as I said, I think the duration could have been a bit longer.
Well, Mr. Sarabji, here's my question for you. This tomorrow afternoon at 4 p.m. would effectively also be 48 hours since the swearing in of B.S. Yediyurappa. This would match the judgment that the court gave in the Goa case as well. So is this now a pattern that 48 hours is perhaps a more appropriate time than the 15 days that was initially awarded?
If 15 days is a bit too long, no question about it. But there cannot be a binding precedent that it should be 48 hours. Depends on the facts and circumstances prevailing in each state. An assessment has to be made of the conditions prevailing. You can't have a general rule, but it should be as short as soon as possible. Shouldn't be for a long period, because that encourages horse trading, poaching as they say, and that's the reason for a short period. But a short period should not be too short.
Well, an interesting thing that did take place, which we're getting information about, Mr. Sarabji, Mukul Rohatgi, the former AG, had initially in the late night hearing come in to represent two MLAs and was not representing B.S. Yediyurappa. It turns out in today's hearing, he was representing B.S. Yediyurappa. Would you think that was part of the legal strategy?
What's wrong in that? I don't see that. He's not in any way disabled from appearing for Yediyurappa. I don't think any objection to that. It's a matter of Voki Rotki. And he thinks there's nothing, no conflict, so he accepted the brief and appeared. I don't see anything wrong in that.
Mr. Sarabji,
has anyone objected to his appearance?
No, I don't believe anybody has objected to his appearance. He had also, when the judge had, or when the bench had suggested a floor test tomorrow afternoon, he initially opposed it. The lawyer representing the BJP opposed it. Could it be because the BJP is not ready, or this shorter time frame might take them by surprise?
Maybe, as I said, the period is a bit short. BJP, other parties would like to gear up, have the people here, prepare them. But now the order has been passed, it has to be followed and complied with. And if Yediyurappa fails to prove his majority on the floor of the House by tomorrow 4 p.m., I'm afraid he'll have to quit.
And Mr. Sarabji, the court has also at this point ruled that he is not to take any major policy decisions, and he is also not to nominate the nominated Anglo-Indian MLAs in the assembly either, effectively only saying that he can act as chief minister after he has done the floor test. Is that out of the ordinary?
Yeah, no, that's correct. It should not be done before. I think that's the correct view of the court. I agree with it.
Right, and the fact that the court is going to continue to hear this case.
I think
do you believe, Mr. Sarabji, there was also a point when Justice A.K. Sikri offered Mukul Rohatgi an option. He said either we set the law right or you agree to a floor test. Mr. Rohatgi didn't agree to the floor test, but the floor test has come anyway for tomorrow. And we do understand from what Dr. Abhishek Manu Singhvi just said to the press that the case is going to continue. The matter is not entirely settled by the court. This was just an interim order. Do you believe going forward the court might set aside, bring in some rules, because this currently is left entirely to the judgment of the governor? Should there be a list of guidelines for that judgment?
Well, they may not or may not. The whole question is, tomorrow is the D-Day. Let's see what happens tomorrow at 4 o'clock, and thereafter we meet again and I may talk to you again. But the point is, Supreme Court has correctly appreciated and reaffirmed the principle, prove your majority, any party, on the floor of the House within a very short, reasonable period. Only dispute is, only controversy is about whether Saturday 4 p.m. is too short or it should have been a bit more. That's about all. But in any case, that's the order of the Supreme Court. It's not interim order. To that extent, it's final. And the floor test will be held at 4 p.m. tomorrow. And
Mr. Sarabji, one of the things I wanted to ask you was during the late night. Yes, during the late night hearing and today as well, the thing that kept coming up was whether or not the Supreme Court's jurisdiction would allow it to bring into question the governor's discretion in choosing one of the two sides. Do you believe that the governor's discretion cannot be brought into the Supreme Court, cannot be questioned by the court or examined by the court?
Normally governor's discretion is not a matter for judicial review unless it's patently wrong, unless he has omitted to take relevant considerations into account or really take any extraneous considerations. But the governor is not above the law. His decision can be challenged, certainly, but the scope of judicial review when it comes to challenging the governor's decision is limited, is restricted. I repeat, the governor is not above the law.
Not about the law.
Mr. Surabji, one very important criticality, and pardon us because we are pressing on that point because we would really want to know what your view on that is. The court today has not disposed of the petition. They have actually only given an interim order and posted it for another 10 weeks when they are saying they will examine the original question of Congress on whether the decision by the governor itself was proper or not. So by that logic, the court seems to believe that they do need to question that as well.
No, I don't think so. Much will depend on the result of the floor test. Thereafter, the court may give a judgment in light of the result of the protest, so it may think it's not necessary to go further. But this order is not an interim order. This order has to be complied with. Namely, floor test tomorrow at 4 p.m.
Yeah, no, interim in the sense of only the floor test, but the petition has not been disposed of. That will still be heard 10 weeks from now.
No, but that will depend on the result of the protest. The petition will be disposed of accordingly. It's a question of really following up the result of the protest. In one sense, you are right, it's not disposed of, but practically it will be disposed of depending on the result of the protest.
All right, Mr. Sarabji, many thanks for joining us here on Mirror Now. We really appreciate the time you've given us. And you're absolutely right. It depends on the floor test tomorrow afternoon at 4 p.m., after which we should talk again and examine this and perhaps re-examine this entire picture when it's done and when it's finally painted, to find out or to look at the dance of democracy here, where the judiciary was also brought in to weigh in on these decisions. And let's also remember that governors are still appointees of the central government, and Mr. Sarabji saying that while the governor's discretion is not a matter of judicial review, no governor is above the law, and that's important. No governor is infallible, and no governor is above the law. That's Soli Sarabji. We have more reactions coming in. I do believe B.S. Yediyurappa has also spoken with the press. Do we have that reaction? Right, we're going to try and get that reaction of B.S. Yediyurappa as well. Ramakant Gaur had a point to make. Mr. Gaur, go ahead, please.
See, this petition was filed by two persons. G. Parmeshwara, who is the president of Karnataka Pradesh Congress Committee, and H.D. Kumaraswamy. Both of them have pleaded that they have approached the governor and their claim has to be entertained first.